Good morning and welcome to the Real Estate Council of BC's Professional Matters webinar. Today's webinar will focus on the impact of cannabis legalization on property and landowners in commercial real estate. Now, if you provide residential trading services or if you provide rental property management, you may want to tune into our webinar this afternoon because that's where we'll be focusing on both of those topics. My name is Elise Palmer. I'm one of the communication specialists here at the Real Estate Council of BC, and I would like to welcome everyone and thank you for joining us. It's my pleasure to introduce our speakers today. We have Herman Lee. He's an associate at the law firm of Norton Rose Fulbright. We also have Neil Davey, who is a partner at Norton Rose Fulbright, and we have Marty Douglas, one of the professional standards advisors here at the Council. Mr. Davey and Mr. Lee practice in the area of real estate law, and they are also the authors of the Cannabis Legalization component of the 2019 Legal Update course. As a partner at Norton Rose Fulbright, Neil is involved in all aspects of commercial real estate, including the acquisition, financing, leasing, development, and sale of residential, industrial, office, and retail properties for local, national, and offshore clients. He's the former chair of the Vancouver Real Property section of the BC branch of the Canadian Bar Association, and he's also a contributing author to the BC Real Estate Practice Manual. Herman is an associate at Norton Rose Fulbright, where he assists senior counsel and advises clients on a variety of real estate transactions involving the acquisition, financing, leasing, development, and sale of commercial, industrial, and residential properties. Marty Douglas has previously worked as a managing broker of several award-winning real estate and insurance agencies. He's also served as a director and president of the Vancouver Island Real Estate Board. And he served as president of the British Columbia Real Estate Association, chair of the Real Estate Council of BC, and chair of the Real Estate Errors and Emissions Corporation of BC. And as I mentioned, he's now a professional standards advisor here at the Council. Welcome to all three of our speakers, and thank you for joining us today. I know that today's topic is of real interest to many real estate licensees, so let's dive right in.
Thanks, Elise. My name is Marty Douglas, and thank you for inviting me to speak to you today. As a professional standards advisor at the Real Estate Council of BC, I value the opportunity to speak to industry members about challenges you are facing in your business and changes that you may be experiencing in commercial real estate. Today, we're going to talk about the new cannabis legislation that came into effect on October 17, 2018, which legalized recreational cannabis production and use across the country. The Cannabis Act's purpose is to protect the public and keep profits out of the pockets of criminals and organized crime. These changes will necessarily have an impact on real estate licensees through influences of cannabis legalization on property and landowners. Specifically, we will cover the new recreational cannabis regime and what managing brokers need to know about how cannabis legalization will affect commercial property transactions. In order to understand the impact of cannabis legalization on commercial trading services, we will discuss the new recreational cannabis regime, the process for obtaining a cannabis retail store license, and the role of municipalities and First Nations. This webinar will allow real estate licensees to assess the suitability of commercial space for a cannabis retail store, as well as identify unique concerns for commercial tenants. Furthermore, we will explain the unique nature of agricultural land reserve as it pertains to the new cannabis legislation. Today, I hope that we'll be able to give you some answers. My co-speaker, Herman Lee, will start the discussion with what the new sales regime means for dispensaries. Herman?
Thank you, Marty. Hi, everyone. This is Herman. It's my pleasure to talk to all of you today. To start our discussion, I will discuss the role of the existing liquor distribution branch, the LDB, and the role of the new liquor and cannabis regulation branch, or the LCRB. The new British Columbia cannabis regime operates through the provincial government's liquor distribution branch as the sole wholesale distributor of non-medical cannabis for the province. The LDB may operate public retail stores and provide online sales. Private parties may also apply for a license to operate their own retail stores, though they are not allowed to sell cannabis online. Only those with a license may legally sell cannabis, and they must comply with the conditions outlined in their licenses. The maximum number of retail licenses an individual or group of related persons may hold is 8. While the government has not provided a specific rationale for this limit, the move may be motivated by a desire to prevent private monopoly in the industry. Some interested parties are concerned about the lack of clarity around being a minority shareholder in a corporation that possesses a retail cannabis store license. The legislation states that a significant shareholder is a person that controls 20% or more of a corporation. This means that, in theory, a person could be a 19% shareholder in multiple corporations and have more than 8 licenses without contravening this requirement. However, another provision gives the government an overarching discretion to refuse a license if doing so would result in one person, through association or financial interest, having direct or indirect influence over licensees who hold more than 8 retail store licenses. Applications for licenses go through the new Liquor and Cannabis Regulation branch. This is an entirely different regulatory body than the LDB, and the new Liquor and Cannabis Regulation branch is also responsible for the initial licensing aspect of the cannabis retail store regime and also for compliance and enforcement. They will be responsible for monitoring the retail sector to ensure that vendors are abiding by the legislation and the terms of their licenses. The new legislation no longer allows for any conflation between the sale of recreational cannabis and cannabis that is provided for diagnosed medical purposes. Previously established and illegal dispensaries will not be automatically granted a license under the new regime. Next, we will discuss the due diligence requirements clients need to perform prior to committing to a property. My co-speaker, Neil Davey from Norton Rose Fulbright, will continue the discussion by highlighting the relevant requirements.
Thank you, Herman. Hello, everyone. My name's Neil, and it's likewise my pleasure to talk to you today. As Herman has mentioned, there are a number of due diligence steps clients will need to perform to ensure that the property is suitable for intended business operations before actually committing to a property. Firstly, an applicant must already own, lease, or have an agreement to purchase or an offer to lease the property. Furthermore, the agreement must be for a minimum 12-month period, and a floor plan as well as a site plan of the location must be submitted to the LCRB. The floor plan has further requirements. It must show all doors leading into and out of the sales area, all entrances to the store, including back doors, the locations of all fixed shelving on display cases, the locations of all cash registers, which areas are public and which are for staff only, and the location of all storage areas. Similarly, the site plan must meet further requirements, including showing the location of the building and where it's located on the property, the location of all entrances to the store, the locations of other buildings and businesses nearby, the entrances to those buildings and their names or a description of what they are. So for example, gas station, office building. The site plan must also display relevant street names nearby and road access to the property, including the locations of any driveways and parking spots. Additionally, both the site plan and the floor plan must match what the store and site will actually look like as government agents will inspect the store. Furthermore, there are additional physical requirements of the retail space. It must be located in a permanent building or structure and be enclosed by floor to ceiling walls that are not transparent. The entrances and exits of the store must not be shared with any other store or business, even if the store is located in the shopping mall. A retail store must also have an intruder and fire monitoring alarm system and security cameras, and any retail product display cases must be locked, the cannabis storage room must be locked, and there must be secure perimeter door locks. Licensees should advise clients to include condition precedents in the offer to purchase or offer to lease, stating that the client, a purchaser or tenant, will only be required to complete the transaction if it is satisfied that the subject property can be altered if necessary to comply with the aforementioned physical requirements, or that the landlord will consent to any alterations required in a leasing context. For an established store, the cannabis retail store license must be posted in the sale area of the store, as well as an approved floor plan. Furthermore, any renovation changes must be approved by the LCRB before commencement. Now I'm going to hand it back to Herman to continue the discussion by underlining the specific leasing considerations.
Thanks, Neil. With respect to leasing considerations, I'll first talk about the very narrow topic of what happens to existing illegal dispensaries. As I previously mentioned, existing illegal dispensaries will not be granted a automatic cannabis retail store license. Accordingly, commercial landlords may be able to terminate their existing lease agreements with these illegal dispensaries. A recent court decision of the BC Supreme Court earlier this year confirmed this general concept. On leasing considerations more generally, licensees are involved at the offer to lease stage in putting these transactions together. When acting on behalf of a commercial landlord for new leases for these cannabis retail stores, you may wish to advise a landlord to include a provision in the lease agreement that requires the tenant to provide copies of all permits and licenses prior to the commencement of the lease term. Other things a landlord might want to consider including as express provisions in the offer to lease are provisions dealing with tightening up the permitted use clause. Landlords may wish to include a permitted use clause which outlines specifically the cannabis retail products that are sold. Specifically, they may wish to address issues such as the sale of edibles and the sale of accessory products, in addition to just cannabis generally. Another thing to consider from a landlord's perspective is the existing insurance coverage for the development. To the extent that the tenant's specific permitted use will result in increased insurance premiums on the development, landlord may want to pass these costs down directly to the tenant in accordance with the lease. From the tenant's perspective, similar types of provisions are engaged. The tenant may wish to review the permitted use clause in detail to ensure that all the products that it intends to sell is covered. Approved alterations, as already discussed by Neil, is also important. The tenant may want to include conditions precedent that means that the tenant will not need to commit to the lease until all its approved alterations are reviewed and approved by the landlord. In addition, since a binding agreement to lease or lease is required before a tenant can apply for a retail store license, a tenant will need to address this in the offer to lease, either by way of including a condition precedent, which means that they will not need to complete the transaction for the premises until a cannabis retail store license is obtained, or they may wish to alternatively include an early termination right. As a last note, it is anticipated that there will be more requirements that will come to be imposed on cannabis retail store license holders as the provincial government continues to develop regulations. For example, it's expected that the government will release a requirement for quote unquote social responsibility materials to be provided by these tenants to their invitees and clients. I'll now pass it over to Neil to talk about specific zoning considerations.
There are several zoning requirements outlined below that a commercial real estate licensee should consider when advising clients in determining what properties in the market meet new regulation needs, even though it is ultimately upon the client to ensure they have met all the requirements. It is worthwhile to keep your client informed of the potential for municipal zoning bylaws to play a role in where retail stores will be allowed to operate. For example, the city of Chilliwack has made no such proposed bylaws, but plans to keep a cannabis retail zone, and several other cities, New Westminster, Kelowna, and Kamloops, have followed suit. Municipalities and First Nations will have shared jurisdiction over public consumption and regulatory compliance. Municipalities without a new cannabis retail zone will retain the power to comment on all applications the LCRB receives, and similarly, First Nations will retain this power on reserve lands. Some factors that may contribute to denying a license are if a proposed store location is close to a school or other place where young people commonly congregate, or if there is already a high volume of retail stores approved within that area. Furthermore, a license will not be issued without a positive recommendation from a local government. At the moment, it is unclear whether or not there will be room in the regulatory regime for a licensed cannabis retail store to be legally non-conforming with existing zoning.
Next, I will talk about the issue of mixed-use developments and strata concerns related to cannabis retail store locations. While mixed-use developments might seem ideal for your clients to open their cannabis retail store, especially in urban settings, there are unique aspects and concerns to raise before their final decision. The Strata Council makes decisions on behalf of the Strata Corporation members for most governance issues, and decisions affecting the strata lots may only be made by the Strata Corporation through voting by the strata lot owners. The new BC Cannabis Legislation does not make any amendments to the Strata Property Act, and the Strata Council and Strata Corporations are able to enact their own rules and bylaws restricting both the use of cannabis and also the ability for cannabis retail store license holders to lease commercial space. To meet a licensee's diligence requirements, licensees should obtain a copy of the strata bylaws and rules and a copy of the strata plan in order to confirm that there are no restrictions on the commercial space preventing their clients from opening a cannabis retail store in that location.
Next, I'll talk about nuisance considerations. As a licensee, you may also wish to warn your clients of the potential for nuisance claims, as mixed-use properties inevitably pose a greater risk of nuisance complaints. Nuisance claims arise when one party has unreasonably and substantially interfered with another's reasonable use and enjoyment of his or her land. The interference can be physical damage to the property itself, or simply something that interferes with the comfortable and healthful enjoyment of the property by the occupant, such as loud noises, offensive smells, or creating a fire hazard. Specifically, you should advise clients looking to open a cannabis retail store that they should discourage customers from loitering outside the space and to wait until they are a safe distance from the mixed-use development before smoking or vaporizing, and furthermore, to take all measures reasonable to prevent nuisance to their residential neighbors. For example, security measures, lighting, proper storage of cannabis product, fire alert system installations.
Now that we've talked about the retail side of things, I'll quickly discuss agricultural considerations and those individuals wishing to grow cannabis under this new regime. Those wishing to be producers or growers of cannabis must apply for a permit through the federal government, Health Canada, which regulates the medical cannabis industry. Health Canada will also take on the role of regulator for non-medical cannabis production, and those producers who are already licensed to produce medical cannabis will automatically be licensed to produce cannabis for recreational purposes. A person must not supply or produce cannabis without the proper license. As noted, local governments have the power to create zoning bylaws with respect to land that falls within their jurisdiction. This power is limited when it comes to the Agricultural Land Reserve, or ALR, property. This land falls under joint jurisdiction with the Agricultural Land Commission. The ALR is a provincial designation that covers approximately 46,000 square kilometers in British Columbia, where agriculture is protected as a priority use. Non-agricultural uses are restricted. This means that while local governments can regulate cannabis zoning everywhere else, they do not have a say on whether or not cannabis will be grown on ALR land within their borders. In response to concerns from local governments, the government of British Columbia has announced that it will allow local governments to prevent industrial-style cannabis production on ALR property.
Thank you, everyone. I'd also like to thank all of the managing brokers who have submitted their questions to RECBC in advance of this webinar. We're going to go ahead and tackle those questions now. Michael asks, what is the status of a medical grow-up that was in place prior to the legislation coming into force? And Neil, I'm hoping you can answer this one.
Thank you. The status of a medical grow-op that was in place prior to the legislation, so long as it was operating legally under the Access to Cannabis for Medical Purposes regulations, continues to exist with this new legislation. So what existed before will exist into the future.
Okay, we got this one from a listing agent. He asked, do sellers need to disclose a previous legal grow-up status? And Marty?
The answer is maybe. It depends on how the legal grow-up was renovated, established. If it had been legal prior to October 17th, then the disclosure that's required conforms to the new amended property disclosure statement. Are you aware if the premises have been used to grow marijuana other than as permitted by law or to manufacture illegal substances? So since it was permitted by law, then the disclosure is not required. However, the next question on the PDF says, are you aware of any material latent defect as defined in Real Estate Council Rule 5-13? And that's more of a concern for the licensee than the legal or non-legal status of the grow-up. If that grow-up had been improperly wired or operated, then the resulting damage to the building may very well be a material latent defect that would have to be disclosed. And so a licensee has to be prudent. On the one hand, you may not have to disclose what was a legal grow-up. On the other hand, you need to have a look at the circumstances around which that grow-up was established.
Okay. Ray asks, he says he's mostly concerned with disclosure rules and if a personal grow-up is going to affect the major bank's ability or willingness to lend. So he says, is there ever going to be a time that previously busted grow-ups are going to be able to be sold through conventional financing? So Herman?
So I think this question and the answer is a bit outside of the jurisdiction of the Real Estate Council. But our sense is, and with the caveat that we can't answer this question on behalf of the banks, we think the answer is really dependent on that individual bank's lending policies. Our expectation is that none of the concerns previously engaged would have changed as a result of the new cannabis legislation. Banks were previously concerned because the value of the property may be detrimentally affected because of property damage caused by illegal grow-ops. Those concerns are still entirely valid and engaged under the new legislation.
So Arnold sent us a question saying, what disclosure is required to be made by a licensee, and what is a material latent defect under the new legislation? Marty?
Thank you. Well, the British Columbia Real Estate Association creates and monitors the property disclosure statement form. And as of October 17th, they modified the forms and remind licensees that there are several forms in use for disclosure. One for residential property, one for rural land and buildings, and also one for strata units. Each of those disclosure forms is different and unique, and it's important that licensees use the correct form. So the disclosure is still required to be made as to whether it has been used to grow marijuana other than as permitted by law or to manufacture illegal substances. But also the material latent defect comes into play. Now that rule, Rule 513, has been in play for several years now, and licensees should be aware of it. It is usually reprinted on the PDS, and it includes defects that are not discoverable by the buyer through a reasonable inspection of the property. They include defects which render the real estate dangerous or potentially dangerous, unfit for habitation, unfit for the purpose for which the buyer is acquiring it, if the buyer has made that purpose known to the seller, or if the seller has otherwise become aware of the purpose. A circumstance that affects the real estate in respect of which local government or other local authority is given notice to the seller indicating that the circumstances must or should be remedied, for example, a lack of a proper building permit, and other permits that might affect the real estate. So all of those fall under the material latent defect, and that is in play under the new legislation.
We also had a question about whether there is any differentiation between a legal medical grow-up and an illegal grow-up. And Neil, I'm hoping you would be able to answer that question.
Thank you. So yes, there most definitely is. One's legal and one's illegal, of course. Being legal, a legal medical grow-op means that you are licensed to grow cannabis under the Access to Cannabis for Medical Purposes regulations, which existed prior to the new legislation coming into effect on October 17th, 2018. Those regulations continue, and to be a legal medical marijuana or cannabis producer, you need to be licensed under those regulations.
We also had a question. Essentially, this person had a client who had plants being grown in a greenhouse outbuilding, and the licensee says they had the Health Canada permit and everything like that. So do sellers need to disclose if they legally grew cannabis in an outbuilding, for example, a greenhouse? And Marty.
Yes, the location of the grow-op on the property is irrelevant because premises include the land and all outbuildings. If the medicinal grow-op was properly licensed and appropriately permitted and then decommissioned, disclosure may not be required. However, were the necessary permits required for the outbuilding? Was wiring redone under a proper permit? So there is always the risk of the material latent defect coming up, regardless of the legality of the grow-op. And so disclosure, regardless of where it is on the premises, may very well be required under material latent defect, even though it may meet the standard of the legality of the grow-op.
Finally, we had a question from someone essentially saying they have more questions, and where do they go for answers about that? So Herman, you and Neil are the authors of the cannabis section in the new legal update for 2019. So maybe you could talk a little bit about what people can expect to see in that section.
Sure. A lot of the content in that new cannabis-related chapter in Commercial Legal Update 2019 will touch on topics that we've already discussed today on this webinar. There's a bit of a more detailed discussion on the disclosure obligations, particularly as they relate to licensees acting on behalf of sellers and disclosure requirements related to properties previously used as grow-ops. So I would definitely encourage licensees that have additional questions on that specific topic and other topics related to cannabis to get their hands on a copy of that publication and to give that a read through.
And now, Marty, just to clarify, we should probably mention that some of the licensees who are listening today will also be required to take legal update for their relicensing education. Is that correct?
Yes, the licensees who are renewing their licenses must take the legal update component suitable to the year in which their license is coming up for renewal. No options there. That's a mandatory requirement for renewal of your license.
That concludes our Professional Matters webinar today on the impact of cannabis legalization on property and landowners in commercial real estate. I would like to thank all of the speakers for presenting today and making this such a valuable learning opportunity for everyone. Thank you all for participating. If you have any further questions, please don't hesitate to contact a professional standards advisor at RECBC through advisor@recbc.ca, or you can email recbc at info@recbc.ca.